This case you sent over about Rainbow Infrabuild, well, it really caught my eye.
Yeah, it's one of those that seems simple on the surface,
Right.
typical insolvency, but the more we got into it, wow.
There's a lot going on under the
That's
surface.
deep dive for a reason, right?
It is. And it's a good one for anyone, really, I think, who's interested in how insolvency proceedings actually work, especially in India.
Oh, absolutely. This Rainbow Infrabuild case, it's like a case study in itself.
So to set the stage a bit, we're talking about a company, an Indian company, that hit some choppy waters back in March of 2023.
Financial trouble, the kind we see all too often, unfortunately.
Right. Ended up in what's called the Corporate Insolvency Resolution Process.
CRP for short.
CRP, right, thanks. And this was due to a petition from one of their creditors, AVB Global Ventures. Unpaid dues, the usual story.
Yeah, that's usually how these things start. Someone's owed money and things escalate. But here's where it takes a turn.
Because typically, when we think insolvency proceedings, we think liquidation is the next step, right? Like it's almost the expected outcome.
Almost automatic. But not in this case. This is where it gets interesting.
The plot thickens because the committee of creditors, the COCOC, the folks representing those owed money, they didn't just jump to liquidation.
No, they didn't. They actually put in a real effort.
They did. Multiple attempts to find a buyer for Rainbow Infrabuild.
Which is unusual in itself, right? I mean, that says something.
It does, like they saw something there, some potential value.
Despite the financial troubles, it wasn't just a dead end in their eyes.
Exactly. And they even, revised their criteria to try to make it more attractive to potential buyers.
Sweetening the deal, you could say.
Mm.
But still, no takers.
So, after all that effort, all those attempts to find a buyer, the COFI makes a unanimous decision.
And it wasn't to liquidate?
Nope. They went with dissolution instead. Which, I have to admit, threw me for a loop a little bit.
It's not the usual path.
Yeah.
So what drove that decision? Well, a couple things it seems. One, they didn't think the company had much in the way of substantial assets to even really make liquidation worthwhile.
So why go through the whole rigmarole and added expense of the liquidation process, right?
Exactly. Might as well cut their losses and move on. And that's kind of what the COSI decided.
So we've got this company, practically no assets, a COCI that's ready to wash their hands of it, and they choose dissolution. Seems pretty straightforward, right?
You'd think so, wouldn't you? But that's where things get interesting.
Oh, there's a but coming. I can feel it.
Always a but, right. So the resolution professional, the RP in this case, Jagjeevan Shah, he takes a look at all this and, he's like, okay, they're right. There's nothing here. Let's just go straight to dissolution.
Makes sense to me. Skip the liquidation, skip the added costs. No point flogging a dead horse.
Exactly. And I'm sure he thought, hey, I'm streamlining things, saving everyone time and money. Good intentions.
Right.
So,
both happen.
Well, the National Company Law Tribunal, the NCLT, they're the ones overseeing all this, and they had something else in mind.
Uh-oh. Sounds like someone's about to get a lesson in following the rules.
Bingo. They rejected Shah's application.
Wait, really? Why?
Because, and here's the kicker, only a court-appointed liquidator can apply for dissolution. The RP can't just do it directly.
Even if it's obvious that's where things are headed.
Even then. Rules are rules, right?
So even in a case like this, where it seems like a foregone conclusion, they're sticking to their guns.
Absolutely. Process over practicality, you could say.
Mm-hmm.
But it gets a little more complicated.
Oh, there's more. Lay it on me.
So the NCLT, when they rejected Shah's application, they pointed out some of the things that didn't sit right with him.
Ah, okay. So more than just a procedural hiccup then.
Exactly. They called out some specific issues.
Like what? What didn't they like?
Well, first off, there was no transaction audit report.
And that's important because
that report gives you the whole financial picture leading up to the insolvency.
Yeah.
It's like the paper trail.
So without it, it's hard to really know what's going on.
Exactly. And that made the NCLT suspicious. They also found some, shall we say, inconsistencies in how the company's assets were valued.
So someone wasn't adding things up correctly.
Potentially.
Yeah.
And that's another red flag for the NCLT. They basically said, even if you claim there are barely any assets, we need a thorough, independent valuation. No cutting corners.
Wow. So not only did the NCLT emphasize the whole follow the rules thing, but they also unearthed some potential discrepancies that need a closer look. This is getting pretty complex, even for someone like me who follows this stuff closely. I feel like we're getting a crash course in Insolvency Proceedings 101 today.
And there are a lot of moving parts.
There are. So for those of us who aren't wading through insolvency paperwork every day, what's the takeaway here?
I think the big thing And this is crucial for any business owner, really, but
Yeah.
especially if you're in an industry where financial ups and downs are common, you have to understand the ins and outs of insolvency proceedings.
Don't just bury your head in the sand and hope for the best.
Exactly. Because when it comes to insolvency, ignorance is definitely not bliss.
Not at all. Knowing your rights, the different players, the paperwork, that can make a world of difference.
Absolutely. And, someone might be listening thinking, well, this Rainbow Infrabuild thing, that's a fluke, a one-off. But here's the thing. What if it's not? What if we start to see more and more of these unusual cases?
Because the world of business is changing, right? And the law might have to play catch up.
Exactly. And that's why this case is so fascinating to me. It raises all these questions about balancing, right? Sticking to the procedures that are in place, but also being able to adapt to new situations that maybe the law didn't foresee.
It's like the more things change, the more they stay the same,
Mm,
but with a legal twist.
I like that. And I think for our listener, the message is be prepared.
Don't wait till the 11th hour when you're already in over your head.
Right. Familiarize yourself with the insolvency procedures in your region, whatever those may be. Talk to experts, get advice before you need it. Think of it like preventative care for your business.
Because, as we saw with Rainbow Infrabuild, even when a company seems like it's reached a dead end, insolvency proceedings, well, they can still throw you a curveball.
They sure can. And navigating those curveballs, knowing what to do, having the right people in your corner, that can be the difference between, total disaster and maybe, just maybe, finding a way forward.
So much good food for thought today. And on that note, we'll leave you with this. How do you think insolvency proceedings need to change to keep pace with the business world? Something to ponder as you go about your day. Until next time, keep exploring and stay curious.